Right to erasure or right to be forgotten, a right given by GDPR to the users that they can request back to erase their personal information permanently to any of the processors. Let's talk about this in this short video. Welcome to my YouTube channel where you have been watching daily new content on data privacy. What is data privacy? My right to choose what personal information do I want to share with whom and for what purpose. And if he wants to share this information with any other third party, then what is the purpose of sharing it with another third party? So when you come to me and say you need my information for a purpose, I would decide whether I want to share or not. And if you come to me and tell me that to complete that purpose you are going to share it with another third party, then again it is my choice to decide whether I want you to share this information with any other third party or not. Right? This portion of privacy is also called consent management, and there are many videos on consent management on my channel. You can get into the details of it. Data privacy gives me the rules and laws that protect my interest in case I see that my personal information has been misused or wrongly shared at some wrong place or with some wrong set of people. Right? So data privacy helps protect my interest in case where my personal information is being wrongly used or wrongly shared with anyone. Right? Now in this also we have a right to share, a right to be forgotten. When you share your information, you know what you are sharing and for what purpose you are sharing. But there could be a situation where at some point you realize that you do not want to continue that kind of processing of your information. It could also be that the information with a particular party is not directly taken from you, as we saw in the right to access, that the information was actually collected from some third party, right? So you can go back to the processor and say that I'm not interested. I want to withdraw my consent. I am not interested. I want to make sure that you remove my information from your record so that you are not processing it again. So let's see how it helps. User has the right to erasure. He can anytime verbally or in a written document form, whichever way the processor is allowed, can apply for a right to erasure. The processor has to validate the request, and on validation the information needs to be erased. Right? Once the processor has validated the request, he has to erase the information within 1 month of requesting the on receiving the request. And if he fails to do that, the user or the individual whose information is being continued to be used and not erased yet can lodge a complaint for any delays and even for any rejection of the request if he thinks that the rejection is illegitimate. He has the right and it should be taken care of. Under what circumstances can you use your right to erasure? Well, when the original purpose of collection of information is completed, an organization collects your information for a particular project and the project is over. So why do they need my information? So I can always say that the project is over, please erase my information, right? If they are not already done. Because there is no new purpose as such that for which you are going to use my information, so please erase my information. I just put in a withdraw my consent, or I just put in my right to object that I don't want you to process my information, and your systems are designed in such a way that the only way to stop processing from a particular task is by erasing the information. So then in that case also, in a way I am using my right to erasure and saying that, or in that case you are actually forcing my right to erasure, saying that because we don't have any other mechanism to withdraw or stop processing, so we'll have to erase it. Information is collected, but it is collected unlawfully or processed unlawfully, so of course I can use my right to erase. And if you have made my information public without my consent, then also I have a right to erase, get my information erased. And you as a data processor has to ensure that you erase it, and you also inform all the respective third parties with whom you shared my information that a erasure request has come in, that information is required to be erased, right? If it is required by law that the information is to be erased, then you have to erase it. And in case of children, the minors, there is a very special emphasis given. Minor information is collected only for the purpose. So it is not only a matter of right to erase. Once the purpose is over, the information has to be erased. And also when the minor grows up and is no more a minor, he is an adult now, then the information might have changed, and then being an adult, he has the right to get his information erased by his own consent. He does not need a guardian or a parent for consenting for him. Exemptions under which the right to erasure would not be exercised or not taken care of: if erasing your information needs impacting certain other records or purpose due to which the general right of freedom of expression is getting hampered, so the right to erase will not be exercised, and of course your request would be rejected. If there's any legal obligation for your information, then of course your right to erasure cannot be used and your request would be rejected. And more importantly, if your information is being used for any public research, especially in case of healthcare, then also the processor can reject your request. You can challenge him otherwise, but he has the right to reject your request if the data has already been backed up, and ideally it should be. So it becomes very difficult how to delete it from archive data. You have a retention period of 10 years, you can't go back and recover 10 years data, erase the user's information and take the backup again, right? So it is expected that you mark that this particular piece of information would never be recovered from these tapes, until of course there is a legal obligation, and it is generally considered that the old backups are kept for legal and compliance reasons. So you mark in your system that says that these tapes are now, or these backups are never going to be recovered until unless required by legal or obligatory things, right? So that's about right to erasure. We will continue discussing about GDPR's user rights in our videos in the future also. Thank you. I hope you liked the content of this video. Please share the bell icon, press the bell icon and like button, and share your feedback in the comment section, and subscribe to my channel to stay updated on the daily new content on data privacy. Thank you.